Hello, happy Memorial Day weekend. Welcome to Legal Briefs. This is the XRP edition and I am attorney Jeremy Hogan. I have one purpose in today's video and just one purpose only, and that is to help you understand Ripple's fair notice defense and why it is so important, not just to this case, but to the whole crypto industry. I'm thinking about it because the SEC just filed its final brief on its motion to strike the fair notice defense, and I will tell you what's happening and about what is going to happen. Now, the fair notice defense focuses on whether Ripple had reasonable fair notice from the SEC about whether its sales of XRP were illegal sales of securities. And to an extent, I have some sympathy for the SEC here because it is attempting to enforce laws written by US courts almost 100 years ago. But good viewers, never fear. Our representatives and senators in Congress are on top of this new area of technology and will be drafting legislation and are currently holding hearings and asking probing questions on the new and emerging technologies surrounding the interwebs.
$100 million a year, you ought to be able to answer that question. Does Google know through this phone that I am moving over there and sitting next to Mr. Johnson? It's yes or no.
I won't be able to answer without looking at...
You can't say yes or no.
Without knowing more details.
Yes or no?
I genuinely don't know without knowing
I'm
what
shocked
services.
you don't know. I think Google obviously does.
How does that show up on a 7-year-old's iPhone who's playing a kid's game?
Congressman, iPhone is made by a different company, and so, you know, I mean...
It might have been an Android. It was a hand-me-down of some kind.
Well, Facebook offered to all of its users a blanket opt-in to share their privacy data with any third-party users.
Congresswoman, yes, that's how our platform works. You have to opt in to sign into any app before you use it.
How do you sustain a business model in which users don't pay for your service?
Senator, we run ads.
I can't wait for the blockchain hearings. Mr. Buterin, isn't it true that the Ether coin is the only denomination? There's no dime or quarter option. Isn't that correct, sir? So, as you may already know, in the SEC versus Ripple case, the SEC sued Ripple for allegedly selling unregistered securities, and Ripple raised two very important defenses. First, of course, that XRP is not a security. And second, and maybe even more importantly, Ripple raised a fair notice affirmative defense. Today, I want to bring you up to speed on whether the fair notice defense will survive and also why it's so important. You might say it's the key. Now, the idea that Ripple should have fair notice about the legalities of its actions stems from a little document called the United States Constitution, the Fifth Amendment, which includes the right to due process, and the very idea of due process of law goes all the way back to the Magna Carta. No, not that Magna Carta, although that one was pretty damn good too. I'm talking about the document King John was forced to sign by a group of barons, which placed the king under the law, so to speak, instead of above the law. And King John was forced into his weak position in part because he needed money to fund the Crusades, and there you have a brief history of the Crusades. And so, in a little twist of long-drawn irony, you have the most important defense to the tyranny of the Ripple case stemming from the tyranny of 1,000 years ago. But I digress. In the Ripple case, right away, the SEC moved to strike the fair notice defense, to remove it from the lawsuit completely. Now, Ripple has responded to the SEC motion, and now the SEC has responded to Ripple's response. So that's where we're at. Now, understand that a motion to strike a defense is difficult to win. The SEC has to get the judge to agree that even if everything in the defense pleadings is true, there is absolutely no way that Ripple can win. It's a very high standard. So, what is the SEC's argument? Now, let's take a look. Its main argument seems to be that Ripple cannot even raise a fair notice defense. Quote, Ripple hangs its hat entirely on Upton, even though Upton has never been applied to negate violations in a SEC district court action, nor has any court allowed an Upton defense to defeat SEC charges of statutory violations, such as Section 5, as opposed to the SEC's novel interpretation of its own rules, as was the case in Upton. So the SEC is trying to distinguish the Upton case and say it doesn't apply here, and you cannot have a fair notice defense in a Section 5 violation case. But that's not the way the law works, even in Chicago. Just because a rule of law hasn't been applied in a specific situation doesn't mean you can't raise it. For example, you all know what the self-defense rule is. I punched you because you were punching me. Now, the rule of law is that you can reasonably defend yourself from attacks. Now, let's say that instead of being punched, let's say a stranger walks up to you and tries to kiss you, and you push that person away from you very, very hard, and you are arrested. Now, you can still raise the defense of self-defense at the pleading stage. You might not win, but you can raise it, and a motion to strike that defense will be denied. Just because no one has ever raised it before in that exact circumstance doesn't negate the defense. And I think the SEC kind of knows this. And so what it does later on is it argues that there's case precedent that states that a fair notice defense cannot be raised in this exact situation. It cites to the Kick Interactive case, which was a case from 2 to 3 years ago against a crypto company called Kick Interactive. And this is what the SEC says. Quote, "Indeed, Judge Hellerstein recently evaluated an Upton defense based on facts materially indistinguishable from those alleged by Ripple and found the defense to fail as a matter of law." Close quote. Uh-oh. That's legal jargon for oh crap. Lucky for us, I have read all of the Kick Interactive pleadings, and this is just not true. In fact, I just pulled it up on Court Listener to show you. Right there at entry number 26, you can see that in the Kick Interactive case, the SEC also filed a motion to strike the defense. In this case, it was called a motion for judgment on the pleadings. And if you go down to entry 29, you can see that the judge denied the motion without prejudice. Now, the Kick Interactive judge eventually did rule against Kick on the issue, but it was not on the pleadings, but later at summary judgment. And that's where I also think Ripple's fair notice defense will be decided. Prediction, motion to strike, denied. But this reply brief by the new SEC attorney on the case does again highlight a problem for Ripple, and it's a problem that the SEC has been trying to capitalize on since day one, and that is the Kick Interactive case. Kick had an ICO in 2017, and it was being sued for the same thing as Ripple is being sued for. The unfortunate thing was, and I don't want to disparage anyone, but the judge in the case was of an elevated age, shall we say, Judge Hellerstein, and he squarely ruled against Kick, ruling that Kick's sales of its coins were illegal sales of securities, and that case was the exact court where Ripple's case is. And it's unfortunate because, like our senators in the beginning, well, I'm not sure Judge Hellerstein really understood what was going on with the technology. Here's me reading from the Kick Interactive hearing involving Judge Hellerstein in a video that I did about the case. September of 2017, Kick Interactive participated, offered, and sold an unregistered security. The court. And that security was SEC attorney. It was a digital token called KIN, K-I-N. The court. A cryptocurrency, SEC attorney. That's one term that can be used. The court. How would you term it? SEC attorney. I refer to it as a digital token or a block key enabled token. The court. A what? SEC attorney. Block key enabled token. It's a token that trades on a blockchain on a distributed ledger. The court. On a what? SEC attorney. Distributed ledger. The court. Distributed ledger? SEC attorney. Yes, Your Honor. The court. I don't know what that is. I love referring to myself as a source. In any case, Judge Hellerstein ruled against Kick Interactive, and the SEC is trying to make the Ripple case out to be just like the Kick Interactive case, and Ripple is going to have to be very careful about that. So in a sense, there's bad luck there having to deal with the non-binding precedent. On the other hand, if you're pulling for Ripple, you can thank your lucky stars that Judge Netburn and Torres are on this case. It's funny how the potential fate of the entire industry can hinge on something as mundane as judge assignments. In any case, one more super important thing I want you to understand about the fair notice defense. I think Ripple's argument that its sales of XRP were not a security are stronger than its fair notice defense, but I think the fair notice defense might be more important, and here's why. The US follows the rule of stare decisis, meaning that rulings from upper courts control the lower courts. The Kick Interactive case is from a same level court, so it's persuasive authority, but it's not binding. If the ruling was from an appellate court, which is a higher court, the ruling would be binding on the Ripple court, which is a lower court. So if Ripple wins on the fair notice defense, it becomes persuasive authority for any crypto company the SEC sues from this point forward. If the fair notice defense survives and Ripple wins, the SEC is going to have an uphill battle winning any other lawsuits they bring. But wait, it's even bigger than that. Listen to this. Even if Ripple loses the fair notice defense, they can appeal the ruling. And if an appellate court determines that Judge Torres was wrong and Ripple did not have fair notice, then the SEC is now really in trouble because that ruling is binding on every crypto lawsuit that comes along. For the most part, the SEC will not be able to bring any more crypto lawsuits, and the SEC is funded by the fines from these lawsuits, so if that happens, well, read between the lines. So the fair notice defense is the main thing right now. It's the thing that is applying pressure to the SEC. It's pressure that's the key. It's the defense that the SEC is most worried about for good reason, and it's the defense that could potentially save the industry from the SEC, and it's the defense that would lead to the case settling or resolving before a hearing on summary judgment. Pay attention to what happens to it. The other stuff that's going on is important, but this is the issue to watch. Happy Memorial Day. Did you know that most of the US soldiers that died in war were 18 to 22 years old? Just kids, really. The older I get, the less I like the idea of people like me sending kids to be killed. We should know better. It's death, not the internet.